PILs, as people know it, is Public Interest Litigation, 𝘤𝘩𝘢𝘐𝑒 we call it. And these are very important tools in the hands of citizens of the country to take up issues that affect larger society, in our case, especially persons with disabilities. Constitution has been a major anchor for all of us. The Persons with Disabilities Act come much after. Earlier there was a 1995 Act under which there were a lot of PILs filed. Then there was an act in 2016 which was brought in to implement the UN Convention on Rights of Persons with Disabilities in the country. So under both laws there have been PILs. So PILs typically are on issues of equality, that equal treatment is not meted out to persons with disabilities, and in the process we find PILs are also filed on lack of implementation of certain sections or interpretations of those sections correctly, and in which court's interpretation really helps in implementing that law for larger benefit of society. So section 32 of the Rights of Persons with Disabilities Act provides for 5% reservation in higher education. But this is for benchmark disabilities, because most of these special concessions or reservations are meant only for persons with benchmark disabilities, and I'm sure by now everybody knows benchmark disabilities are 40% and above specified disability. Now recently, looking at the experience, a lot of seats were going vacant because not sufficient number of people were there to fill up these benchmark seats reserved for benchmark disabilities in education institutions, universities and higher learning centers. So recently a case has been filed in the Delhi High Court. In the process, what we found was a lot of people not with benchmark disabilities but persons with disabilities who have been defined in the law as persons with disabilities. They were not getting that benefit, and this petition has been filed in the Delhi High Court to say that these 5% seats which are meant for persons with benchmark disabilities, if there are not sufficient number of benchmark persons of that disabilities available, they can be given to persons with disabilities who may not be that benchmark. The High Court, the judges of the High Court found a very good reasons to admit the petition, and a notice has been issued to Government of India. And we hope that there will be a good resolution of this issue, because eventually the larger benefit should be of persons with disabilities, and seats meant for them should not just go away. So the first one that I can cite probably, which is pre-2016, was how reservation is given to people with disabilities. Earlier, if you see, the objective of the Act is that minimum 3% reservation or 3% seats need to be reserved for people. I'm talking of the earlier Act. But what happened during those days was, people were limited to 3% by many employers due to wrong interpretation. So what will happen if there are 100 seats? Typically they will reserve 3% seats, and if there is any additional person coming in on his own merit, he would be typically adjusted within those 3 seats. So in a way to say, if there are 10 people who have gotten the list, they'll say, okay, we have only reservation for 3, so we'll take 3, rest 2, you go back home. Major PIL on this was filed, I remember in probably 2005 or during 2007 that we filed this petition against railways. I remember me filing it for All India Confederation of the Blind, and in this the court came out strongly and to say that the law's basic requirement is, or basic intention is, to minimum 3% reservation. It's not maximum. So therefore you cannot first of all restrict people to, within 3%. Second was, if there is a person with disability who is coming on his own merit into the merit list, then he should not be forcefully shifted to the reservation quota. So all people who are coming in their own merit in the list, they would be given in the merit list, and below that, if there are other people, they would be adjusted against the 3% quota. So this was, I'm talking of initial days when these PILs were filed, and very good interpretation of the law, that law means 3% minimum and not maximum. So eventually in practice we were turning it to maximum. That's one. Let me come to post 2016, the law post 2016, when the Right of Persons with Disabilities was passed. At least 2-3 important cases which I find are really of larger significance is Vikas Kumar judgment. This is from the Supreme Court, in which the court held that reasonable accommodation is of very important requirement to implement the Rights of Persons with Disabilities Act. I can cite another example of another bench in the Supreme Court which held that the question before the court was whether a blind person can become a judge. So I remember this case, we have taken up these cases before the Chief Commissioner and way back probably in 2007 and 8 when the court held yes, people with blindness, the position or the position of a judicial magistrate or a judge is identified for people with blindness as well. So therefore, see, typically Government of India has these list of identified posts which are meant suitable for persons with certain category of disability. And post of a judicial class or judicial magistrate or JMFC class 1 was one of those posts. So eventually using that tool we had argued that matter, but in the Supreme Court when this matter, another matter, not the same matter, another matter that went up to Supreme Court was probably it was from Tamil Nadu, if I correctly remember, where it was a reasonable restriction was put by the state that people with 50% disability probably can only become judges. So low vision maybe they can become judges, but not blind people cannot become judges. And we were really taken aback, but the matter went to Supreme Court and Supreme Court bench said to become judges you need vision. And so therefore, if what High Court has done, what the authorities have done is correct, so and they had actually disposed of that matter with this, and this actually brought a lot of our efforts to, they became futile with all that exercise. But this matter was also challenged in the Supreme Court. And when this Justice Chandrachud became Chief Justice, and there was another matter, Vikas Prasad, as I said, in which the issue was of reasonable accommodation. In this case, what happened was reasonable accommodation would eventually mean that you're providing a level playing field, additional support to the person with disability so that he can perform at par with others at the workplace. So here in this case, the matter went that there was a person who did not have a disability of 40% or benchmark. He had a writer's cramp. Writer's cramp is typically you can't write appropriately like other people. So he said that he needs a writer, whereas the authorities who were to give the writer said, no, you don't have benchmark, so we cannot give you. They simply denied, not looking at the need of the person. So the concept of reasonable accommodation is very need based as to if my need, for instance, if I have sugar or have diabetes and if I need to take frequent breaks at the workplace, that's a reasonable accommodation. If I can't write with my right hand or with both hands due to the writer's cramp, can somebody else write? I dictate, somebody else write. So these provisions that already exist, but they were earlier existing only for benchmark disabilities, and they were sort of being implemented that way. So court in this Vikas Prasad case said that the reasonable accommodation will not depend on the degree of disability. You cannot say that since the person does not have a benchmark, he will not be given reasonable accommodation, because this law defines persons with disabilities and persons with benchmark disabilities separately. And non-discrimination is something which is very basic to all categories of persons with disabilities, not only for persons with benchmark disabilities. And court also reflected upon the earlier judgment by fellow judges, by brother judges, that in the other case, the bench probably did not look at the concept of reasonable accommodation, because with reasonable accommodation, blind people can also effectively function as judges. So with this judgment, the justice was served, and the concept of reasonable accommodation got its own place. So if we look at the Rights of Persons with Disabilities Act, it provides for that transport, public transport, will be accessible to persons with disabilities. And during 2010, Delhi had Commonwealth Games, and we had all these low-floor buses. I can cite how these low-floor buses actually came in. There was a gentleman called Dinesh Gupta. He was a person with cerebral palsy. He was a student of Adi. Earlier it was used to be called as Special Study in Northern India. This fellow used to travel every day to 𝘠𝘓𝘐 from his home in Moti Nagar in public transport, and he used to walk with a walker. And he would have endless falls. He was a person from a good family background. He could afford a car, he could afford a driver, but then he would always insist that he come in a public transport to the school. He would fall, he had ruptures on his skin, and every time he used to fall, but then he continuously used to use this public transport. He came up to the Court of Chief Commissioner saying that the public transport is not accessible and law says the transport should be accessible. And during those days, the Chief Commissioner called upon DTC and Delhi Transport Corporation to say that the buses need to be accessible. Why can't we buy accessible buses? So the Delhi Transport that time did some adaptations, and buses were cut from the back and ramp was created to address his needs going through his route. But eventually we said it's not just one person. There are so many others who probably would benefit if the public transport is made accessible. So under these backgrounds, with a recommendation or order from the Court of Commissioner on Disability, that the Delhi government brought in and decided to bring in the low floor buses, because that example existed in other countries. And a whole fleet of low floor buses was brought in Delhi. People tasted the benefits of accessible transportation, and since then we have had these these low floor accessible buses which had two major features. One was like kneeling features, and other one was a ramp which could be just simply manual ramp which could be opened up and people could easily go in without a major problem. So they were going on. What happened? The Delhi government wanted to bring in some buses, and eventually even tender was floated for semi-low floor buses or little high floor buses which are not accessible to persons with disabilities. And one of the gentlemen, a person with disability himself, Nipun Malhotra, he approached the Delhi High Court to say that challenging this advertisement or challenging this tender, that the buses cannot be brought in Delhi and unless they are accessible. And the Delhi High Court was, the justice was pleased to pass this order that yes, no buses can come on the streets, no public transport can come on the streets unless they are accessible. So this is what the law says, and the courts have held that any transport which is meant for public need to meet the guidelines of accessibility. One more matter that we all should know is 𝘲𝘁 Ghosh versus Union of India. Now in this instant matter, what happened was when 𝘲𝘁 Ghosh was travelling for a conference, probably to Goa, and the pilot offloaded her, just saying that she was probably drooling. She is a person with cerebral palsy, for information, and she walks with a slight different gait, and she has also slight drooling because of her disabling condition for cerebral palsy. And this pilot, she was already seated in the aircraft, and he simply offloaded her, saying that probably she will be a threat to the flight, and 𝘲𝘁 missed her important conference and a lot of hue and cry, and the matter was reported into the media, and gradually court took notice of that matter. And the matter went on for a longer period, but then eventually the court came out very hard against the airline to say that it is a question of dignity of persons with disabilities. It is a question of respect, and as equal traveller, you cannot discriminate merely on the basis of disability. And the court awarded a compensation of 10 lakhs which was to be paid by the airline to 𝘲𝘁. So that was one part of it, but the matter went on for a pretty long time, where this matter also impacted how the DGCA civil aviation requirements on carriage of persons with disabilities by air were also got to be modified gradually. We all were party to that discussion with the Director General of Civil Aviation when we made a lot of changes into that car. So due to this small PIL and due to this matter, a lot of things became a little more inclusive for promoting inclusive travel for persons with disabilities, for travellers like 𝘲𝘁.
I'm very happy that the court has given a fantastic judgment. Personally, I have been compensated, but more than that, this has become a landmark judgment in the disability sector, which is helping the sector in other cases. A lot of changes have been made because of this judgment. So I'm very happy about this.
In this regard, I think we can go a little before 𝘲𝘁 Ghosh, when 𝘤𝘩𝘐𝑚𝑒𝑒𝑑𝑖, who was the founder of the NCPDP, he was being lifted manually by certain airlines, and he felt this was really undignified. And he filed this very important case in the Supreme Court, which he argued himself, and to say that the airlines must provide accessible boarding into the aircrafts. So you can't manually lift me, which is also risky for me as well as for those 4 people who are lifting you, and it can be really risky. It's a hazard for people. So, and the Supreme Court came out finally in the case and ordered the I remember that time probably was Air India or Indian Airlines, I don't correctly remember, but it was Air India perhaps, that the Air India need to provide ambulifts for accessing the aircraft. So there, from that point onwards, all the airlines were mandated by law, and this was also reflected in the DGCA car, that they need to provide accessible, if there is no accessible chute to go into the aircraft, you need to provide ambulance services. So that was a major PIL which brought about a lot of changes in how travelers with disabilities were looked at by the airlines. So I want to cite another matter of Jija Ghosh. She's, as you know, she's a person with cerebral palsy, and she's a married woman. She wanted to adopt a child, and when she already zeroed on a child in probably in Odisha somewhere, and she wanted to adopt the child, but the agency, the adoption agency or the organization, they refused to give the child in adoption looking at the disability of Jija, saying that you are a person with cerebral palsy, you can't walk properly, how would you can't take care of the child, so we cannot give the child in adoption to you. And that was such a, we looked at that the whole matter was such a lack of awareness among people. People with disabilities study, they get employed, they marry, they raise a family, they live a life in the community like anybody else. So how could a person probably looking at disability, discriminating against a person merely on the ground of disability that the person can't adopt a child? And this matter, it did not go into litigation, but yes, legal notices were served and they were shown the mirror as to what you are doing, and this is incorrect, this is law, and this is a question of dignity. Eventually, after a lot of these hassles, what we are trying to say is that there is a lot of lack of awareness in the community. People in the community do not believe on the abilities of persons with disabilities. They just look at, okay, this is half glass empty. They don't look at this, it is half glass filled as well. The people have residual abilities, they also lead their normal lives, and like anybody else, of course little differently, but they do also need. So now Jija, her daughter and husband, this is a happy family now.